Yeah. Dim the lights. Pour that drink. It's candlelight and confessions with Mel. Late night vibes, city lights glowing. Truth in the air, yeah, you already know it. No judgment here, just honesty. Heartless stories, real transparency. We talk love, we talk pain. We talk things you're scared to say. If it's heavy on your mind tonight, come stay.
Hi, everyone. Thank you for joining me, and welcome to my Candlelight and Confession with Mel. So, here's the latest update in the Romeca Blackmon case involving Quadajah Johnson, a.k.a. Holly. All right, so the state of Illinois has officially filed a petition for leave to appeal with the Illinois Supreme Court. I have read it, but I'm not going to read everything. I did want to go over something, though. So give me a minute here. I'm going to try to bring it up right quick here. All right. Let's see. It's something that I wanted to bring. I should have highlighted it. All right. Here. The evidence that the state proffered at the hearing was that on September 8th, 2025, Ms. Johnson was in a relationship with Carlos Smith, the father of her 6-month-old, and the child she was pregnant with. Keyword, she was pregnant with. I just wanted to, I read it all. I'm just not going to read all this, but I did want you guys to see that for some that was asking whether she is or not. It seems like it says was, past tense, okay? So, let me go back here. I just wanted to point that out because I've been asked that a lot. And let's see here. She's still in jail. She's going to stay in jail. All right. And so until all this is over, depending whether the Supreme Court picked this up or not, the state still remains in effect. Okay. So here's the latest update. Now, the state of Illinois, as we know, they did officially file as of May 18th. And what does that mean? Basically, the state is asking the Illinois Supreme Court to step in and review the appellate court decision that would allow Quadajah to be released with conditions. Okay? So now the state is arguing a few major things. First, they believe the appellate court minimized the seriousness of the shooting by calling it a personal dispute. Second, they say the appellate court gave too much weight to Quadajah not having a violent criminal history. And thirdly, they arguing that the appellate court made it too hard for them, which is the state, at the detention stage by almost expecting prosecutors to fully disapprove self-defense before the trial even starts. Okay? So, the state also did point out, back to the original facts presented at detention, including that Romeca was allegedly unarmed, and the shooting happened near school, and the witness stated Romeca was backing away when shots were fired. Now, on the other side, the appellate court previously ruled that they appeared to be very personal conflict, that Quadajah had sought a no-contact order before, stayed on the scene, cooperated with the police, and that release conditions like firearm restrictions could potentially manage any danger to the community. Now, as you remember, we talked about this. One appellate judge strongly disagreed, though, saying the shooting itself showed an ongoing danger to public safety. So right now, as I said earlier, the stay remains in place while the Illinois Supreme Court decides whether they will take the case or deny it. If they deny it, the appellate ruling likely stands, If they accept it, the case enters another major legal phase. Okay? So people were asking, how long is it going to take? Okay, for the Supreme Court to rule on whether they would take the case or not. Now, it depends on, like I said, they did it May 18th. The defense usually gets time to respond to the PLA. Okay, so the defense gonna respond. I'm pretty sure Ari gonna respond. And then after the briefing is completed, the Illinois Supreme Court reviews the paperwork privately and decides whether to accept the case or deny the petition. Typically, we can see a decision anywhere from a few weeks to around 2 to 4 months. And it can take even longer. It depends on if the court is backed up or not. Or if they wanted an extended review. That takes time, right? So it can take longer than that. So the Supreme Court, again, the Supreme Court does not have to take this case. They choose which cases they believe involve important legal questions affecting the state. But I feel like they're going to take this one because this kind of determined. I mean, just think of all the people that's in Cook County Jail now. That kind of similar case and didn't get let out because they felt that there was a danger to the public. This is a big one. So, the state filing is clearly typing to the frame like, this is bigger. It's bigger than Quadajah Johnson, okay? They're arguing this could affect how pretrial detention and self-defense claims are handled. Statewide under Illinois' Pretrial Fairness Act. So the Supreme Court will kind of likely look at questions like, well, did the appellate court create a rule that could impact future murder detention case? I think so. Did the appellate court improperly raise the state burden at detention hearing? Mm-hmm. Does the issue need clarification for all Illinois courts? I believe so. So those are the questions that they're going to be looking at. So right now, the Illinois court is basically deciding if the case is important enough to review statewide. The decision could come in weeks or it could take months, like I said before. Until then, that stay remains in place, meaning the release order is still on pause, and most likely Holly will still be hearing this all day long. So that is all I have for you today. And until next time, I'll see you later. Enjoy the rest of your evening.
Dim the lights, pour that drink. It's candlelight and confessions with milk.